Let's go.
You're listening to Making Data Simple, where we make the world of data effortless, relevant, and yes, even fun.
All right. Hey, everybody. Hopefully you're extremely well. Making data simple here, making AI simple, making patents simple today. Back with me is Robert Plotkin, attorney. He's the founding partner of Blueshift IP, leading provider in software patents. He's the author of The Genie in the Machine, How Computer Automated Inventing is Revolutionizing Law and Business. I had Robert on in November of 2023. It was so good that we did part one and part two. And I was just checking my notes and stuff and then recognized, we had you on again, I think, in December of 2024. That's how popular you are. And we talked about technology for mindfulness. Listeners, if you're listening, you've got to go back and listen to some of this. I mean, we talked about what is a patent, the process. We talked about patent law, whether it was ready for AI, patenting an algorithm. We talked about patent, the approval process, the costs, the coolest invention. We had advice for law students, which my daughter, who is a lawyer, took kindly. He said that if he wrote another book, we'd come back on, and guess what he did? He went out and wrote another book. That book is called AI Armor, Securing the Future of Your AI Company with Strategic Intellectual Property, an Amazon bestseller. It's talked about attracting investments, generating revenues. I'd even call it maybe a playbook to obtaining IP protection. Anyway, that's my lead in, Robert. Thank you for coming back. I appreciate you.
Thanks so much for having me. I really appreciate it. Yeah, I wrote the book just so I could get back on it.
I knew you would. Look, a lot to go through. I thought it was an easy read. Look, I have a list right now and all the stuff that I've been going through. I'm reading The Jolt Effect. I'm reading The Geek Way. I finished, almost all these, but I'm reading yours, The AI Armor. I've got it right here. And I'm also getting ready to read Nexus by Yuval Noah Harari. So you're in great company here, man. Great company. Like I said, I have tons of notes. Everybody needs to go back and listen to the previous podcast. We're not going to go through those, but I'll have you introduce yourself again. But look, welcome back. You doing all right?
I'm doing great. Yeah, staying busy, working on tons of AI-related patents and innovations. As you know, the pace of innovation is just incredible right now.
I have a question on that, by the way.
Yeah.
Look, you just moved?
Yeah, moved. Fairly local move, but as you know, it's always a little bit hectic to move to a new location.
It doesn't matter if it's local. I moved like 5 miles, and you still got to pack everything up. That's the problem. So it doesn't matter. Might as well move to, across country, which I didn't. Please introduce yourself, give us a little history and what brings you here, and then I'll jump into some of my notes.
Yeah, as you said, I'm a patent attorney. I specialize in obtaining patents for software. I represent companies of all sizes, always tons of startups, really enjoy representing startup companies from the ground up. They're motivated by some great new insight, new problem that they see as unsolved, and they've come up with some kind of new technology for solving it. We handle all kinds of software, and of course, increasingly in recent years, AI. I started out, I think I told you last time, as a kid programming computers back in the early 80s. For those of your listeners who are old enough to remember, my first computer was a TRS-80 I programmed in BASIC. And,
awesome.
The thing that comes full circle with the AI revolution is that what got me hooked on computers was the ability to sit down and write code and have the computer do what I told it to do. That just felt so amazingly powerful. That's what got me hooked. The first time I used ChatGPT a couple of years ago, I felt like I had that whole experience over again, but in a new way, with the ability to use natural language to control a computer. And I suspect that many people who didn't previously code like I did had that experience of power and amazement for the first time when they first started using something like ChatGPT, because it just enables you with words and language to express your ideas, what you want to accomplish, and have a computer transform that into reality. And actually that was what caused me to call the first book The Genie in the Machine. Was the realization that that's fundamentally what computers are. They're these incredible machines that let you control them with words. Now, it used to be those words had to be written in these very specialized programming languages, right? C or Java or Python and so forth. And now, increasingly, you can do a lot of the same things in natural language. So it's opening up innovation to a much wider range of people. It's being called the democratization of AI, and it's enabling people who have the older technical skills to become a lot more powerful, efficient. There will be a $1 billion unicorn created by a single person at some point in the not too distant future, powered by AI, where you won't need a team to do that. Just an incredible new age that we're in now, fueled by AI. And I'll stop here and say the two flip sides of the coin are it's incredibly empowering. And that also means, though, that the competition is fiercer than it's ever been before, right? Whether you're talking about the biggest companies in the world who are all competing against each other, it seems almost every day leapfrogging each other, right? With the latest model or application or something like that. And with small startup companies constantly coming out with new stuff that's leaping over the previous generation of technology. So it's an exciting time and also a nerve-wracking time to be in the innovation business because of how rapidly everything's advancing and because of how many more players are entering the field and how fast everything is moving forward.
But I love how you're going all in. You seem super energetic around it. When I do pitches, I often say much of what you're saying, in that now AI has made language a technology. And that's what we think in terms of language. We act in everything that we communicate. It's amazing. And the speed is out of this world. My first question then is this. Prioritize these for me. Who are you? Are you an author, an attorney, or a technologist? Which one of those?
It's a great question. I mean, I spend most of my waking hours being an attorney.
Still number one. No, it pays the bills. Unless the AI armor is paying the bills right now. You tell me. I don't know.
No, the AI armor is a way of spreading the word about what I do, how I help companies obtain strategic intellectual property protection for their technologies, and then leverage that IP protection to raise money, to protect themselves against competitors, to maximize their company value, to get acquired or merge or achieve some other kind of exit. That's what the book is for. And it's also to just share my strategies. I've come to believe that I only benefit from giving away the strategies essentially for free. I have the confidence that any company that really wants to benefit from those strategies isn't going to try to do it at home, so to speak, and do it on their own. And they're going to know that to really execute on those kinds of legal strategies, they're going to need to come to someone like me, a patent attorney who has a lot of experience doing it. So, you can read the book, and I very freely share what kinds of strategies I use, but to actually execute them and make them work, you need the experience, and that's what I have, and that's why clients come to me.
Yeah, it makes perfect sense to me. Like I said, it reads like a playbook to me. I mean, it'll give you the prescription. You still got to do it, and you still got to have the experience, to your point. But so does that mean attorney and then author second, or technologist second?
Technologist at heart, I would say. So probably author second and technologist at heart, but it's not what I spend my time doing. It's what motivated me to enter the field of computer science and eventually to move on to law in a field where I get to work with incredible innovators all the time.
But you do have some technology in here. I was looking through some of this stuff. You start going into AI and some of the intricacies of AI that, you got to know AI. To talk to it the way you have. So kudos. All right. So I think I might have asked you that before anyway, but I'm going to go with attorney, author, and then technologist in that order. Second question is, why do another book? You had the first book. I'll just pause there. Why do another book?
Yeah, great question. The first book was more theoretical. It was published in 2009 when AI was being used to augment the inventive process. People were using the AI of the day back then to do things like design new drugs, invent circuitry, even to write software. But it was quite primitive compared to what we see now. And very, very few people were obtaining patents on inventions that were created using AI back then. So I was motivated to write the book because I could see it coming. It being the revolution of AI that would fuel the inventive process in a way that we would see an explosion of inventions that were created with the assistance of AI, and then people patenting or attempting to patent those inventions, and that the legal system would then start struggling with these questions such as, can an invention created with the assistance of AI be patented? Could you or must you name the AI system as an inventor on such a patent? What are all the other implications of AI fueled inventing for patents? That's what motivated me to write the first book. But the first book was mostly theoretical, I would say, and high level strategy. I was motivated to write the second book to go into much, much more detail about exactly how to obtain patents for AI assisted inventions and what different types of AI technologies can be patented and how, in light of all of the incredible advancements that had been made in AI in the 15 years since I wrote the first book.
I'm not going to repeat our earlier podcast, but just to kind of set the floor, the foundation, because I don't know that we have experts. Well, we may have some experts in patents, but I'm certainly not an expert in a patent. But just to kind of set the stage before we go into some other areas, can you talk to what can be patented and what cannot?
With respect to AI, I'll give a few good, easy to understand and common examples. Methods of training a model. Those can be patented. There's a lot of innovation going on now, right, in better training algorithms. Methods of applying or executing a model, doing inferencing faster, right? Lots of commercial incentive to come up with ways of speeding up inferencing. All kinds of applications of AI. There's all of this emphasis now on applying AI within specific verticals, like law, like medicine, like autonomous vehicles. There's tons of new applications of AI, which individually can be patented. Other, of course, huge field everyone's working on is agent-based systems. And how can you make those systems work effectively and efficiently, particularly when using current types of models like large language models. If you come up with a new architecture for an agent-based system and are able to describe how it works and why it's better and more efficient or more effective than previous ones, that's something you can patent. Really, any kind of method that's performed by AI or using AI, if it's automated and implemented in a computer, it's something that you can patent.
So I talk to a lot of entrepreneurs, new startups. They find their way to a podcast, and I usually have brokers that reach out to me. When I listen to you and when I've read the book, the thing is, for you, maybe this comes as secondhand. You're very well versed in it. You've got the experience, even though we've got the manual right here. It seems to me this is hard, meaning I don't know what to patent or not. A lot of times, I think a lot of these entrepreneurs, they don't know what they have, what they don't have. In fact, as you know, most startups or many startups, you end up going towards a direction you didn't even intend. It's kind of like what I say is like somebody gave me an analogy one time where you throw the dart on the wall and then you move the dartboard to the dart, if you will. I mean, that's what startup is like. I mean, Slack, perfect example. You probably know Slack. It didn't start out as Slack. That was a tool that they used and they figured out that was better than their startup. They pivoted. So, I mean, you don't know what you have. And then you're looking at it and you're saying, look, this is going to take a big, long process. I don't even know if it can be upheld anyway. I'm going to have to put a lot of time into it. My time I need to be spending on developing and driving this business. Should I always have a patent attorney on like a retainer? What is your suggestion there? Yeah. What should I be thinking as an entrepreneur?
It's a great point. Patents are not the best strategy in all situations for all companies. I think it's always a good idea for a startup who's developing a new technology to at least consult with a patent attorney early on, because if they do have something that's highly patentable and that would really benefit from patent protection, it's best to find that out early on, because filing a patent application early is really beneficial. The key cases in which patents are helpful for a startup are in which they've developed something that is really technologically new. Again, some new kind of algorithm that works more efficiently than any competitor before, that solves some sort of technical problem, which would be in high demand by competitors, particularly by bigger companies, and which would be easy or inexpensive for a competitor to recreate or reverse engineer once they see it, particularly if it's something which is visible to the end user when they use the product. That combination of features makes a really good case for patent protection. Because if you've got a feature which was really tricky or required some real genius to develop, but once you start selling your product, your customers or your competitors can see that feature, say, this looks great, and then knock it off pretty inexpensively, a patent may be the only thing you can really use to stop that. On other cases, and I talk about this in the book, if you have some new algorithm that's highly innovative, but it's not visible to the end user, it's working under the hood, then you've got a choice to make about whether to patent that or to keep it as a trade secret. And in some cases, maintaining it as a trade secret is a better strategic choice. And there's a lot of factors that go into account that you have to consider when deciding between that patent and trade secret decision. So to answer your question, patents are not always appropriate. They're not always maybe the best use of funds, but in the cases in which they're useful, they're really, really useful. And they could protect you against being run out of business by a peer or a larger competitor who can see what you're doing, just knock you off and run you out of business.
It seems like there's a little bit of luck here in terms of looking at that crystal ball and saying, all right, I'm going to do this or I'm going to do that. Look, I don't want to stop here because we had so many other questions to ask, but that trade secret, it gets confusing. I mean, Coca-Cola, by example, I don't think they ever patented their recipe, but they kept it a secret. Should they have patented it? Could they have? I mean, is it just a trade secret? They've amazingly kept it behind closed doors. I mean, till now, I still think it is. But anyway.
Yeah, in retrospect, I would think we'd all say it was a great decision to keep it as a trade secret because they have been so successful at keeping it secret, and at other people, no matter how hard they've tried, being unable to reverse engineer it. But these things, in retrospect, are often easy to see whether they were a good or a bad idea. Mm-hmm. If it had turned out that Coca-Cola's key competitor had been able to recreate the formula within a year, maybe it would have been a better decision to patent it. And that's why I say sometimes it's not possible to really know fully in advance which decision is right. And in some respects, you can hedge your bets. You can do things like file a patent application as a provisional patent application to hedge your bets. That buys you a year of time in which to decide whether to keep pursuing patent protection or not. In the field of AI, that year can be a long time, to put in a small investment to decide whether to then fork off and go back to trade secret protection or continue investing in patents. Another thing you can do if you're going to file patents in the US only is you can file a patent application and keep it secret the whole time it's being examined, unless and until it's granted as a patent. And I have clients who do that, which means they're pursuing the patent. It's secret. It doesn't get published. That might go on for a couple of years. If the patent doesn't get approved, they abandon it and the patent application stays secret. No one gets to see it and they don't reveal how they're doing what they're doing. But if the patent gets granted, it gets published, but at least my client has protection for it. So that's one strategy for hedging your bets of patents against trade secrets. Again, there's a lot of other ones.
So if Coca-Cola would have came to you in 1899 when they were selling bottling rights, would you have instructed or had them file a patent? It's easy to look back, but would you have said, hey, you need a patent for this? You're crazy for not doing it.
The conversation I would have had with them, which I have with all clients, is the crystal ball one I mentioned, which is to ask them as the technical experts, how likely do you think it is that when you sell this and anyone can buy it, take the soda out of the bottle, analyze it chemically, and try to recreate it, how likely is it, do you think, that they'll be able to succeed? And we would have had that conversation and made a decision about patent versus trade secret protection. Who knows whether I would have been right in what I advised them about in the end.
This brings me to the next question. That was a time when things were slow. I mean, really slow. At least compared to what we're talking about today. We're in light years. I mean, we're beyond Moore's law at this point in time with technology, right? So what I don't get is, and you started this conversation with talking about how fast things are moving, speed. In my mind, when I think patents, I do not think speed. So I think part of me, if I was an entrepreneur, yeah, I could be guilty of going on to the next thing and skipping the work around a patent, even, if it's simply just filing it because, man, it's going to change overnight. I don't even know what I have. I don't even know if this is worth it. And the technology is going to be gone before I even get that patent.
It's a long-standing concern. It is true that the normal path to getting a patent can take a few years. But in the US Patent Office, you can pay a small additional amount to get on the fast track. So they call it track 1. I've gotten some patents granted in 6 months that way. It speeds up the process very significantly, and particularly with startups, very often, increasingly in recent years. My startup clients have filed at least their first patent application using track 1 to try to get something granted. You're not guaranteed to get it granted that quickly, but you speed things up very significantly. So then you can have a granted patent in your hand in under a year in some cases. The other thing is, you have to evaluate what the nature of your invention is. Sometimes you've developed something that has a broader applicability and longer lasting power, so to speak, or at least you have a good idea that it will. You have an innovation that's more groundbreaking. And in those cases, even in the software field, even in the AI field, something might be valuable for 5 to 10 years. In which case getting a patent granted in 2 or 3 years can still be very valuable. And it's also the filing date of your patent is really important. If you file the patent application now, you can release your own product. Your competitors can release products. They can file patent applications after you. And if your patent application filing date precedes them, then when you get your patent granted, you can still enforce it against those other parties. And so, as much as we like to say that things are moving so quickly that they become obsolete quickly, that's not always true. So it's another reason why you need to evaluate everything on a case-by-case basis. And I'll say this, for startup companies that are looking to get acquired, it's often valuable to file patent applications that have some staying power so that it can add value to the company for an acquisition by a larger company who could make use of those patents over a longer period of time.
I'll take that. But let's assume that you get this patent. All right, everything's good. Maybe it's a provision or a temporary provision, whatever. You got this patent going. I think the next question that comes to mind, and I'll tell you why, it's kind of a silly question. Can you even enforce the patent? Or is it even worth it to enforce it? I mean, because it could take years. I mean, I may lose all my money before I get there. Who knows? I may be even out of business. And one reason I ask that is because if you know the AI world, like I know you do, there is so many models, foundational models, large language models out there that are scraping the internet that are paying no mind to copyrights or anything right now. It's to hell with it. They're just doing whatever that they want to do. So if they can do that and get away with it, then why would I think my patent's going to have any meaning?
No, it's a great question. Look, patent litigation in the US in particular is very expensive, very time consuming. So you might ask, and many people do, why would I obtain a patent if I'm not going to be able to afford to enforce it? And the short answer is that very often you can get the benefit of your patent without having to enforce it in court or without having to go to the full length and expense of a full-blown trial and a verdict in court. So if you get a patent, a strong one, that's infringed, you can often negotiate a license agreement or sale of that patent, depending on what you're looking for, without ever having to file a lawsuit. That's the first thing. It's the walk softly and carry a big stick strategy, where the mere threat of patent litigation against another party can often bring them to the bargaining table. Even if let's say that the other party who's infringing your patent doesn't agree to negotiate with you, and you do file a lawsuit. Most patent lawsuits don't go to the full length of lasting for years and costing millions of dollars. They usually settle far earlier than that. So that's the second thing. Third thing is that's increasing availability of contingency fee patent litigators who, if you're a small company or even an individual inventor and you don't have the funds for patent litigation, if you have a great case for patent infringement, a litigator will take that case on for a contingency fee, which means you don't pay them unless and until they recover something from you. And the last thing on top of that, which is even in addition to contingency fee lawyers, there has been over the last 10 years or so, growing industry of financing for patent litigation, where there's third-party funders who will pay for patent litigation if there's a strong case, which again, as the patent owner, it means you either don't have to pay anything or you only have to pay a much reduced amount in the litigation fees up front because some of it's getting funded. Of course, the contingency fee law firm, if there is one, will get a cut of the proceeds. The funder will get a cut of the proceeds, but it can enable small patent owners to proceed. I have had even individual inventors move forward against the biggest companies in the world in that way, which has enabled them to litigate when they wouldn't have had the funds to do it otherwise.
So I have my own theory on this, though. Then why do a lot of these big companies building large language models, why are they ignoring copyrights, even personal information? Are they just going to pay it out?
Yeah, that's my suspicion. So I'm much more versed in the patent world. My suspicion, this is my suspicion that on the copyright front, that companies have been making a bet internally that they could grow fast and large enough on what's actual or potential copyright infringement in their training, so that by the time they have to pay out, they'll have earned enough revenue to be able to make those payouts. Look, we saw it happen previously in the early days of the internet with the music streaming, right? Mm-hmm. Same thing happened, and eventually there were a bunch of deals made that settled all of those disputes, and people walked away happy, at least most of them. So, and so I suspect that that's been the thinking, that, we've got, you could think, if you want to simplify it, two categories of copyright holders, right? You've got the big ones, New York Times of the world and Getty Images and, large companies that have huge amounts of copyrighted material. And then you've got individual authors and artists. I suspect the large copyright holders will end up striking their own deals with the AI companies. It'll be interesting to see what form those take, because they could take a lot of different forms. We don't know what the future is going to be. I hope that smaller authors, musicians, music artists, video producers, all of those people are going to get something good out of this. Unclear. Maybe there'll be some sort of collective arrangement like there is for music licensing for individuals, but I don't know.
Look, I tend to think the way you think. I mean, it was a time to market issue, and they just said, look, we're going to take a chance and we'll pay at the end. Hopefully, we're going to make a ton more money than we're going to have to pay out at the end of the day. Another question on this, and maybe this ties into your mind process that you could talk to, the 4 stages of the mind process where you tailor your IP strategy. I see so many things going open source. In fact, I'm at IBM, and we're putting a lot of our models completely open. But I see so many things and technologies being placed to open source. Kubernetes. Why wouldn't you patent that?
Yeah, it's not an easy question, but I think the basic consideration is usually where is it that we're going to make our money, right? And by open sourcing something, will we grow the pie big enough that we will then maximize our revenue from something that takes advantage of that bigger pie, right? So you you grow the market for the model that's open source, and then you're going to make your money from services or applications that leverage that model. That, I think, is the equation generally. And who knows in advance whether you're right, because just as we said with Coca-Cola, right? And whether you're right or wrong is easiest to figure out after the fact. When you see whether you really grew the pie big enough to maximize your profits on the applications, and maybe afterwards you say to yourself, you know what, maybe it would have been a better thing to protect that with a patent or keep it as a trade secret or something else. It's really hard. I don't pretend to know that. I don't know that anyone knows that. Anyone who tells you they know in advance what the right answer to those business model questions is I think, is trying to pull the wool over your eyes.
But you do have a process or processes. You tell me if I'm right or wrong, if I've got this right, but you've got what you call the mind process, where you tailor your IP strategy, or you get to the point where you can make a decision. Can you talk some more about that?
Yeah. So this is what I describe in the book, 4 stages for deciding what type of intellectual property protection to apply to your own AI innovation. So you're developing some sort of new AI-based technology, and how do you decide whether to patent it, keep it as a trade secret, apply copyright to it, open source, etc.? These are really complicated questions. So the first step in that process, the M in the mind, is what I call mapping, which basically means breaking down your technology into its components so that you can analyze them separately. It seems like an obvious thing to do. You might say, Robert, what's the big deal? Wouldn't anyone who's developing a new technology say, it's a car. I've got the wheels, I've got the engine, I've got the seats. I'm going to look at each of those and decide whether to patent, trade secret, or et cetera. But it turns out that in the case of AI, I've seen so many companies really not do that kind of decomposition of what they have. And I can tell when they're not my clients that they sometimes haven't decomposed things, because I can see a patent that's been granted which describes and discloses everything in the AI system together. And I can look at it and say, you know what, it might have been a better idea for that company to have patented one part of the system and kept another part as a trade secret. Like kept the training method as a trade secret and used and patent the application of the trained model, for example. And it's easy to make that mistake.
Let me pause there if I could. Why wouldn't you just, if you're already patenting one part, that's where I'm so confused. Why would I use the other one as the trade secret? Why didn't I just patent the next one if I could?
Let's use an analogy in the industrial age, right? You've got your Coca-Cola, and you've got some super efficient method for manufacturing shipping the bottles, right? That happens in your plant in secret. It's an industrial process. You might keep that as a trade secret, but maybe decide to patent the formula because that's something that your customers have access to, and you're concerned that they'd be able to copy it. So very often there's different aspects of the same product. It might be a method aspect versus a product aspect, or even 2 different components of the same thing that you might apply different types of intellectual property protection to. In a computer, very often there's parts of a microprocessor that companies will keep as a trade secret because they think it's hard to detect infringement of it. Even biggest companies in the world like IBM, Intel, they will often keep parts of their microprocessors as trade secret or just not patent them because they think, look, if a competitor of ours copies this small component of the microprocessor, how are we going to know? Are we going to reverse engineer every microprocessor that our competitors come out with and analyze every small component of it? It's going to be expensive. And it's going to be hard for our competitors to copy our microprocessors directly for the same reasons. But you might patent other components of the computer that you sell because they're easier to copy and easier to detect infringement of. So there's lots of situations in which you've got an overall product in which you might patent parts of it and not patent others, and maybe even keep parts of it as a trade secret. And the same is true. The same is true for AI. And I stepped through in the book a lot of the common elements of an AI system, like the part of it that does training, the training data is another super valuable aspect of most machine learning systems. You have to decide there. If you generated the training data, for example, do you keep that as a trade secret? Do you license it? Do you just keep it solely internally? So the mind process involves breaking down all of the aspects of the system and deciding which then, so that you can decide in the next steps which form or forms of intellectual property protection are most suitable to it.
All right, cool. Well, I interrupted you. You were talking about mapping, and you can go into the next one. By the way, when you did start breaking some of that stuff down, that's where in the book I was like, this guy's pretty technical. He knows how it works. So good for you. Go ahead.
It's okay. I think that the main, without going into all 4 steps, the main thing I would tell people about the overall process is that you have to clearly identify what your own business plan is and what your business goals are, so that you can decide which form or forms of intellectual property protection are best suited for you. Because, for example, I work with some companies who decide from the beginning that they want to develop a technology and primarily out-license it. They're not planning to be in the business of developing and selling products to customers that incorporate their invention. They want to primarily license. Right? I've got other clients who say, no, we've got a product, right? We're almost ready to go out the door. We want to get a patent that's essentially going to block competitors from selling knockoff products of ours. That's what we want a patent for. I have other clients who say, you know what? We want patents because we're looking to get acquired fast. We want to get acquired in the next couple of years. And we know we've got these acquisition targets. We know they like companies that have patents. So depending on what your goal is, that's going to influence whether you patent or not, what you patent, and even how I write the patent applications. It's going to vary depending on what your business goals are. So the 4 steps of the mind process are all tailored to choosing, designing, executing, and implementing intellectual property in ways that promote your specific business goals. And so whether you patent or not is going to be influenced by what your business goals are. It's not just that, if you have something that's patentable, that therefore you should file a patent application for it. You might have something that's super patentable, but it's not the best business decision for you to patent it. Or you might have something that's only arguably patentable, and it's iffy, and it might still make good business sense for you to file a patent application for it, depending on what your business goals are. So basically the message is, let your business goals drive your IP strategy as much as you let the legal requirements and whether your technology satisfies the legal requirements for patent or trade secret drive your IP strategy.
What do you think is the best technology patent? I was reading about this, and like the ones that came to mind, Amazon's one-click patent. I think that's the one click to purchase. Snapchat's tap and hold camera patent, where I think, and look, I'm not an expert here, where you just use that one, you could either do a picture or you could hold it and then do a video. They said that was like over $1 billion patent in value. Any other ones that really come to mind?
There's one that's quite old now, but it was probably a giant in the software patent world, which was RSA's original encryption patent. And I say that because it was a early broad software patent on RSA encryption, which became the standard for many, many years. And because it was early, it was broad, and it turned out to be the method of encryption that was most widely used on the internet and financial transactions, all of RSA's competitors had to license that patent from them. I mean, they raked in untold millions of dollars on that patent. People tried to invalidate it and couldn't. And there were reports that when that patent expired, 20 years later, that RSA's competitors threw parties because they didn't have to keep paying royalties on that patent. But the patents you gave examples of are good because a patent that's in a sense simple but very innovative, broadly applicable, and easy to detect infringement of, meaning that as the owner of it, when you see someone implementing your patent, you can tell right away. And if you had to prove it to a jury, you could prove it very easily. Those make for really, really good patents.
And remind me, what you got? 20 years start to finish? What?
It is now 20 years from when you file the patent application, which in the software world, in most, the RSA case is unusual, where that technology was still widely used 20 years later. In most cases of software, that's not the case. But yeah, 20 years from filing.
Is that the same for like drug companies as well?
Yeah, it's the same. It's the same for drug companies, which is why big drug companies are famous for doing everything they can to get around that requirement and file new patent applications on minor variations in their drug or new uses of the drug or something else to sort of effectively extend that 20-year period, even though technically you can't extend it because, for blockbuster drugs, you could have millions of dollars of revenue per day on those.
You talk about this in the book, but is this the new gold rush? The AI gold rush?
It sure seems to be for many reasons. One is that, as I mentioned right at the beginning, AI is making it possible to innovate in really powerful ways with smaller teams and at lower cost than ever before. The newest latest generations of AI technology are opening up all new types of applications that weren't possible before. I mean, just think about certain things that we now take for granted. Ability to do image recognition, all the multimodal capabilities of the latest models, right? Text to image, image to text, that just a few years ago were either impossible to achieve or that you had to do lots of detailed, expensive, complex coding to do or pay for expensive software to do. And that's now become ubiquitously available, cheaply or almost for free. So it's a gold rush in the sense that you could say the availability of that kind of functionality has opened up a whole new field for innovation. What we always don't know in advance is which of those innovations is going to be broad enough and have enough staying power to enable some company to forge ahead with it, ahead of its competitors, rather than just be another one of many fairly incremental innovations.
It feels like the Wild West sometimes. And speaking of the Wild West, another silly question, but these are the kind of things I think about. We've got AGI, in the future, perhaps, and it depends on who you talk to, but let's say AGI is in the future, general intelligence. We are certainly doing agentic AI, where AI algorithms can essentially make decisions and take actions, sequential actions, multiple tasks at any given time. Here's the question. I think I know the answer to this question, but I think you'll probably have a response. And that is, does AI have an identity like a corporation? Who's going to be responsible for some of this stuff when things go wrong? I mean, at some point in time, the AI algorithm is going to create an AI algorithm that's going to do something that the original creator had no intention of. Who's responsible?
Yeah. I mean, you're asking about when something harmful happens, right? Who's going to be legally responsible for? Right. Yeah. Because patent law is my expertise, I'll say there's an equivalent question in patent law, which is who is the inventor or who is entitled to the intellectual property rights in those kinds of situations. That's the thing the IP world is grappling with, meaning if someone invents the AI that creates something, is the original inventor entitled to some form of IP ownership in what we call the downstream invention?
That was actually my next question. Actually, it was AI patenting AI in the future, or AI inventing something that goes back to anyway, you got it. I'm getting confused with all this stuff. I mean, it's like a vicious circle.
And there's another angle to the same question, which is if you have someone who creates something an AI innovation, and let's just assume that they create something that's patentable, but it's so powerful that it enables a whole series of other innovations to be created fairly easily. Should those further innovations be patentable, or should they be considered what we call obvious within patent law and therefore not patentable anymore? Where it was only the original innovation that should be patentable, and anything that flows from it, it was so easily created as a result of the original AI that no one should be entitled to patent protection in it. That's really an open question now. I think the bigger question you're asking, which is a great one, which again we can't predict in advance, is will there come a point at which the AI will become either so powerful or self-sustaining, that it's going to make everything else we're working on now or in the future moot. In the patent world, for example, and just in the innovation world generally, there's an open debate, right, about should you attempt with the existing models to build powerful applications that solve particular problems, or should you not waste your time because in tomorrow there'll be a new model that on its own will be able to do the same thing without you needing to build an application on top of it. So I think there's the model camp who says, let's just keep making the models more powerful and eventually they'll be able to do everything. And then there's the other camp, which is, no, we either can't rely on models, or they're going to be too expensive or power hungry or something else. We're always going to need to build applications that leverage models. And I tend to be in the application camp, maybe because I'm a patent lawyer. That's where I sit. But I don't know, because maybe tomorrow that model will come out that makes all the applications moot.
I know you're a patent attorney, and there's many forms of attorney, but do you have any perspective on the who's responsible if AI creates some AI that creates some AI?
I'll go back to law school tort class. Yes. And in torts, like negligence, there's this standard of what would the reasonable person have expected.
Right. This is gonna be fun, man.
Right? And so you could ask that if someone releases an AI that does something like sucks up all of the power from every power plant in the country, right? And you sue the creator, what would you say? You might say, well, you should have known. It was negligence for you to release that thing onto the world, because you had in tort law, you have to say you had a duty to the person who was harmed, and then you failed to satisfy that duty, and had some reasonable expectation that your failure would result in the harm. These are the legal standards that have been around for hundreds of years, going back to English common law. And I guess that's one way to look at it. But who knows what's reasonable to expect in this context when you're talking about brand new technology that we've never experienced.
I think English common law is so far away from where we are today. I mean, the laws that we have today are not written in any way, shape, or form of the technology that we have before us, and it's moving too fast. It really comes back to speed, and boy, it's going to be a brave new world. See how fast an hour can go? This has been a fascinating discussion as always. I appreciate it. You're always well-spoken. Look, I think the book is a very easy read, and that takes talent to make it easy, yet very impactful and informational. I thought it was very honest and straightforward. And you've mentioned many times on this podcast that sometimes patents are not the right mechanism, and you really need to think about that. And you give a prescription and or a practice, if you will, on how to do that. However, I would still, as I started the podcast, would probably have at least a patent attorney on retainer as I was starting a business, just to make sure that I'm running ideas by that individual as I go along. Otherwise, I think I'm going to miss some things that are very obvious, and I'm going to try to patent the things that really they're not gonna bear fruit. Let me end with just a couple things, and that being, look, who do you think should read your book?
Yeah, it's for founders of startups in the AI world. It's for executives at those companies. It's for investors in those companies. It's for anyone who's advising growing AI companies. As you said, I think you just put it really well. Even although patents aren't always the right tool for startup companies, if you do really need one, and if you would really benefit from a patent, it would be a shame to not get one and then find later on when it's too late that you needed a patent and now you don't have one. And so I would recommend the book to anyone for that reason, so that if you read it and it sparks you to think, oh, this really applies to me, and patent protection is something we should really at least seriously look into, then you can contact me. Even if it's just to do a review and say, you know what, patents aren't right at this time, or they're right in the future. I very often speak to early stage companies where I say, you know what, I don't think you have something that's either patentable or worth patenting right now, but it looks like you're heading on a path to develop something in the next generation of your technology that would be really beneficial to patent. So for all of those reasons, it's good to at least have the conversation with a patent lawyer early on.
Speaking of contacting you, where can folks reach you?
Yep, you can go to blueshiftip.com. That's my law firm's website. You can contact me there. You can go to LinkedIn. I post tons of free content targeted at tech company founders, executives, investors, advisors. I'm at linkedin.com/in/Robert Plotkin, or I'll just give you my email address directly, rplotkin@blueshiftip.com.
Anything you're reading right now? I mean, you're done writing the book. Anything you're reading that the listeners would be interested to know about?
I don't have any current books open at the moment. I'm sure that at the holiday time, I'll sit back down and open up the Kindle at the tons of books I bought and haven't started yet.
You're Kindle guy over hard copy?
Most of the time, yeah.
Most of the time. Any hobbies? New hobbies since the last time we talked?
Probably the same as always. Music is a big one for me.
Good. What kind of music?
I play a lot of blues. I play keyboard. Blues, boogie, jazz is my forte.
What's the third book going to be, by the way?
I don't know yet, but these books come out of client experience. So after the next couple of years of experience with clients and see what they're all going through, the trials and travails and successes, I'm sure I'll come up with the next one.
Robert, thank you for being here. It's been excellent to talk to you. And thank you for giving me the book. I thought it was really good. Really good. And I would recommend it to anybody listening.
Thanks for having me.
And podcast listeners, thank you. And we will see you on the podcast. Hey, hit us on almartintalksdata@gmail.com if you have comments, questions, concerns. Yeah, keep your concerns to yourself. But if you have questions or you want to make recommendations, we'll take those. Thank you, and we'll see you on the podcast. Bye-bye.